But for now, let's go ahead and have Bob with his hot topics.
All right, thanks. So if you can, even if you're not getting CEs and don't care about the certificate, please just stay in your seats just for a couple minutes. We promise it'll go quickly. She's got this very well organized. You will get out on time, maybe even a couple minutes early. And the idea is if you start getting up and organizing your stuff, the other people won't be able to hear their instructions to get their CEs. So everybody just stay in their seats just for a couple minutes. Promise we'll get you out on time. Okay, raffle time. All right, hot topics. All right, so we're going to start off with a couple different things. One of the things that is somewhat unique about us, and we're getting back to this, some of you may be familiar with our care coordinators that we've had in the past, our elder care coordinators. So in the past, we've very much relied on our elder care coordinators as part of our services. And we've always done it, but we're starting to, get back into using more elder care coordinators. So we have an elder care coordinator, and I want to kind of describe what an elder care coordinator does. Partly because I want you to understand what our services are, but also, we're always looking for good people. We're certainly not going to poach from any of the regular places, but if you just know somebody that might be appropriate for this, we're certainly always looking for great people. So care coordinator is typically a professional such as social worker, counselor, nurse, gerontologist, specializing in assisting older people and families in attaining their highest quality of life under their circumstances. Conducts assessments and identify problems and assisting in solving them, assists families in identifying and arranging in-home help with other services, reviews medical issues and offers referrals to geriatric specialists, coordinates with the attorney to help conserve financial resources, provides support, guidance, and advocacy during a crisis, provides education, counseling, and support. So this is our way. I'll give you a quick example. One of the issues that sometimes we all probably have experienced is a difficult person to get services for. They sometimes nicely refer to it as behavioral problems. In other words, they show aggression or things like that. And so those are hard, those are hard to find the right placement and figure out. And, ideally, we're not trying to drug them into zombiehood, although we've had cases that was the only option, and I hate that, but there are those cases where we just have to calm the person down. But a quick example of this is we had somebody like that, and our care coordinator was able to spend enough time with the family, and it was something that I know that I can't do, and I know probably that you can't do. We were talking to discharge planners one time, and we were saying, we have this resource for you, a toolkit to help go through all the different options for discharge and where they could go next. And the feedback I got was, they don't give me enough time for all of that. I'd love to be able to do that. I'm not allowed to because they don't give me enough time for that. Well, our care coordinators can spend that time. They can spend the time with the family. And so in this particular case, the gentleman was getting aggressive with the staff of a care facility. And they, when we had him on certain drugs, and we're like, oh boy, is there anything we can do to fix this? After spending hours with the family, our care coordinator found out that it seemed like any time that he was watching cowboy movies, he calmed right down. And we taught the staff that, and we made sure he had all these VCRs. It was back when they had the VCR tapes, and that's what he had. So we made sure we bought a VCR and got the tapes there. And instead of drugging him, every time that he started to show any kind of aggression, they'd pop in a movie, calmed him right down, made his life better for the final couple years of his life. That's something that you can't usually do unless you spend the time, and that's what a care coordinator can do. Now, obviously, that's a sort of an extreme example. That's not what they're doing on a daily basis, but you can't really provide that kind of level of care unless we can spend the time. And that's the goal of our care coordination program, is to help people through these things. Okay. So the other thing I want to talk to you about is, when we first started boot camp many years ago, we were sitting at a class, and we were thinking about, boy, it'd be great to be able to share resources and share help back and forth. But as a business owner, I was also thinking it'd be nice if people would refer us appropriate families to be able to help. And so I do ask that if you find people that you think we'd be able to help, that you'd be able to refer us. And so we have what I'm referring to as the VIP referral line for social workers and long-term care professionals. So you haven't heard much from Liz, but you've seen her. She's been sitting up front. She's been our timekeeper. She's our VIP referral line. So we've got a whole process to screen, because we get lots of calls, and we want to help everybody, but not everybody's appropriate for our services. And sometimes they're calling for a divorce, and sometimes they're calling for a traffic ticket or whatever. And so we have a whole process of screening and making sure that they go through the right steps. But for you folks, I'd like you to be able to bypass that and go directly to Liz, and Liz will then contact you and kind of give you the sort of straight route to refer people in. So feel free to reach out to Liz. It's just liz@mannorlaw.com, and then just our Grand Blanc phone number is 810-694-9000. And eventually, if you had referred somebody, they would have gotten to Liz anyway, because she kind of does we call it triage of our long-term care cases, but you can just go directly to Liz instead and bypass our regular process. All right, so into the hot topics. This is actually a really interesting thing that occurred. So remember that case that Kelly was talking to you about where they put up the fence around the people's house and all of that? I'm not going to say that's what caused this, but it was certainly part of the reason. It got the governor's attention, it got the attorney general's attention of Michigan, and they got involved in that case, and they got, and they may have already planned on doing this, but seemed to have some impact on it, that they started this elder abuse task force. And so the Elder Abuse Task Force has been a really interesting group. They've had these before, and what they've done in the past is they just kind of issued a report, and nothing really happened, right? Maybe they passed another law that really didn't do anything. But they've been very, very serious about this Elder Abuse Task Force, and they've included all of the relevant communities. They've included the long-term care community, they included the Attorney General's office, they included several elder law attorneys. One of my close friends has been very active on the Elder Abuse Task Force. And they included banks, they included just all of the different people that could be involved in this. And they're proposing a number of legislative changes in addition to other things. One of the big ones they're focusing on is that what sometimes we kind of refer to as guardianship abuse. And this is a tough one for some people. I clearly think that there's some guardianship abuse. But I get it, it's tough. You're trying to get a stranger to come in and take over somebody else's affairs, and they don't know the situation, they got to take over. But there's definitely, the example that Kelly gave you, that's not right. That shouldn't be. And maybe you've seen that movie. Anybody seen that movie, I Care a Lot? It's an extreme exaggeration, but there was a reason why somebody got the idea for that movie, and it's because there's been some crazy cases. There was a crazy case out of the Las Vegas area where there was this woman driving around trying to find people to get guardianship on. And in Nevada, she could get temporary guardianship without even giving them notice or the family notice. And in this one particular case, she showed up somebody's door with this temporary guardianship and said, I'm your guardian now, you got to come with me, you've got 5 minutes to gather some things. And she took away their cell phones and things like that. Daughter comes by the house that lived nearby. She comes by the house, 5 hours later, her parents are missing. She had no idea where her parents were. And then in that particular case, the guardian typically sold the house, liquidated the assets, put them in an assisted living of her choice. It was crazy. Parks, I think, was her last name. Anyway, obviously, I think she might have even been charged criminally at this point. But so the idea is, how do we fix this? And it turns out that it's a little harder than it seems. And I can understand the judges' positions, the probate judges. They've got a difficult role. They've got a difficult position. And so sometimes they're feeling under attack right now because of this elder abuse task force. But the reality is there's problems. It's just they're really hard problems to fix. A couple of things they're doing is trying to make it so that if you have more than a few if you have more than a few wards and more than a few people that you're guardian for, you have to go through some kind of certification. They're trying to make it so, and this is my personal opinion, not necessarily the opinion of the Mannor Law Office, that sometimes judges had a preference for public guardians over family members that were qualified and eligible to do it. And that's not what the law says. The law says family members have priority. And in my experience, there were many times where judges had a preference for public guardians. And so they're trying to reverse that, things like that. But I think it's overall a good task force. Again, they've just got a really challenging job. Remote witnessing and notary. So this was really kind of nice. In Michigan, our section, as Savannah said, that I just became chair of this section for the state bar on, Tuesday? Our section was very instrumental and probably the leading push to get the governor to issue a temporary order, an emergency order, so that we could get legal documents signed during COVID, during the shutdown. Because those healthcare documents that you sign, they have to be witnessed, not even notarized, witnessed. But there's very severe restrictions on who can witness them. Cannot be witnessed by a caregiver, cannot be witnessed by a hospital employee, cannot be witnessed by any caregiver, any employee of any caregiver organization, cannot be witnessed by a family member. So when we were in shutdown, who did people have access to? Caregivers and family members, and they couldn't even get their healthcare documents signed. And so, and then the same thing with notarization. There wasn't a remote notarization law, but it was through these third-party companies, and these third-party companies made it extremely difficult to use them. In fact, basically, when we reached out to them to try to use them, they said, we don't want to work with you. They really only wanted to do real estate deeds. They only wanted very simple one-page, two-page documents. They weren't interested in doing anything more complicated than that. So the governor and many lawyers throughout the country, I was part of a national task force on this, and then I was chair of co-chair of the committee that was trying to get this pushed through in Michigan. And I've talked to people throughout the country. We actually got one of the better orders in Michigan. It was hard. They made us jump through the hoops. They made us record everything, and we got to keep that recording for 10 years, and we had to do exactly the right process to follow to get a remote witness and notary. But basically, we could do it one of two ways. We could get them the documents, their family member or whoever could get them the documents. They turn on the camera on their phone or on their computer, and we watch them sign after we ask them specific questions. There was about 10 minutes worth of questions we had to ask them first before we could do this. And then the other way is probably the way that you've signed documents, but you can't typically do it for wills and powers of attorney, is you push a button on the computer and it says you signed it. That was the other way that the governor allowed us to do it. Well, that kept getting extended, and then even when that was overturned by the Michigan Supreme Court saying the governor didn't have that authority, the legislature actually passed a law saying we're going to extend it just the way the governor wrote it. Okay, so that was cool. It expired July 1st. So then we're working on, and we have a lobbyist, and we're working with a specific legislator to try to make that permanent. It probably will be slightly different than the law that we had been working with. The concern is that, well, then anybody could get a document notarized or witnessed, and you're doing it remotely. You don't even have context of the person. In my view, it's actually much more safe because it's almost certainly there's going to be an attorney involved. We have it on video that we got to keep for 10 years, that we have a recording of what happened there, which we normally don't have during witness and notarization. And we've got to jump through all these other hoops. When we were meeting with the legislator that was going to propose this, there was a bunch of groups, the bankers and the other groups, and they were like, well, we don't really need this anymore because, people are meeting again and we can access it. And we said, no, for our clients, we need it. And they said, well, and one of the attendees said, well, can't you just throw mom in a wheelchair and wheel her over to the bank and get it signed? It's like, not everybody has that. Yeah, they didn't have an understanding of the folks that we're dealing with, and that's not always a possibility. And so I really think there's a real good chance that we're going to get this passed. I think we have just a very good argument for this. So we're hoping sometime this session that we will get that passed. So we all know about this, the isolation that folks experienced during COVID. And all the rules that were passed that we had to isolate, we had to close down places. And so I just wanted to talk a little bit about some of the new rules from CMS that provides regulations for all care facilities, basically nursing home, assisted living, memory care. Says that all visitors are supposed to be screened, even still. They prefer outdoors, but we're in Michigan, so it's just a preference. Does not require it to be supervised. One of the things that there was a question about is, does it have to be supervised to make sure they don't touch each other? CMS says no, it doesn't have to be supervised. That shouldn't be a restriction. Prefer social distancing, obviously. Visitation should be suspended if a staff person tests positive, but ideally that you're restricting you're suspending the visitation only to a section. If that person only worked in that section, ideally we're limiting it to that section. And of course, compassionate care visits are available and have always been available for someone that's dying, or there's other reasons why there's a compassionate reason to allow for visits. Okay, I want to talk just a little bit about this. So I've talked about this for years now. This goes back a few years. But Medicaid is still technically has on the books penalties for paying caregivers. So if you try to stay in your own home and not go on Medicaid, and you don't jump through all the hoops that they make you jump through, like having notarized contracts that are signed by a doctor and itemized what the caregiver does, technically they're supposed to penalize the payments that you made for that. And so this all came about because Betty Jensen was a woman, lived in a small house, very minimal means in Muskegon, and she lived there and didn't want to go to a nursing home and wanted to stay in her house. And she was able to stay in her house with the help of a caregiver, with the help of a neighbor. Teresa was the neighbor. And over a period of 11 months, she paid like $18,000 or $19,000. It's pretty reasonable. That's not a whole lot of money. When she eventually ran out of money and eventually did go to a nursing home and apply for Medicaid, the caseworker, I think inaccurately, said, oh, that $19,000 that you paid Teresa is going to be treated as a penalty, treated as if you gifted it, because you don't have a notarized contract signed by a doctor. Not because they questioned that Teresa did the work, or that she came over every day and helped her out and helped her get meals and helped her get ready and helped her get dressed and helped her get groceries, took her to the doctor, did all these things. They didn't question that. They said because she didn't have a notarized contract with Teresa that was signed by a doctor. And so a local lawyer said, that can't be right. And they appealed it. And it got to the circuit court. And the circuit court judge said, that can't be right. And so there was two issues. One was whether they could pay Teresa, and they said, yes, you can pay Teresa, that's not a penalty. She also had reimbursed her grandson, because her grandson was helping her out, and reimbursed him for gas, reimbursed him for, he went out and bought prescriptions for her, and she reimbursed him. And the circuit court judge said, no, because there was no contract in place there, I can't, he did treat that as a penalty. Here's where it gets weird. The state of Michigan decided to appeal that decision for this person who was already poor, hadn't tried to save any money, hadn't tried to protect any money, and was just trying to do what everybody thinks we should do, which is stay home and stay off of Medicaid. And they appealed it to the Court of Appeals, and the Court of Appeals agreed with the state of Michigan, again, I think wrongly, and said that we can penalize that person because they didn't have a notarized contract with Teresa. And so Betty was penalized. Who gets penalized? Betty can't pay that penalty. Who gets penalized? The skilled care facility never got paid because Betty didn't have any money to pay that, the penalty. And so the whole thing was ridiculous. So the state of Michigan then decided to go and change their rules to make it comply with that court case. So I think the court got it wrong based on the way that the rules were written back then. But they went back and changed their rules to comply with the court case to say anytime we pay a caregiver for home care, it can be treated as a gift or a transfer or a penalty unless we have a notarized contract signed by a doctor. So I am advising folks, let's comply. They're very spotty in whether they enforce this rule or not. In fact, we've even heard them tell us that that's not their interpretation of the rule or whatever, but that's the way they wrote it. And so they're very spotty in enforcing this rule. Out of the abundance of caution, I recommend that if you are paying a caregiver at home, we go ahead and do the care contract, we get it notarized, we get it signed by the doctor. If you don't have that, we've always found ways of advocacy to work around it. As part of the Elder Abuse Task Force, they're looking at, and I've mentioned this earlier, possible changes to the power of attorney laws. Specifically, those extraordinary powers that I talked about, the extra authority, the extra power, they're saying, boy, that sounds a little risky. We're giving extra authority to somebody. What if somebody's signing this and they don't know what they're signing, and they didn't really mean to give that extra authority? And that's a legitimate argument. So initially, they were saying, well, we should just make it so you can't. So that's illegal. You can't give that extra authority. And so we were able to lobby, and I have a friend on the task force, and they were able to kind of get a compromise that says, no, that's a legitimate argument, but we still need to have people have that ability if they really do understand and it's been explained to them. So basically, the proposed law would make it so that there has to be an attorney that certifies that power of attorney that says, I was there, I explained it, they understood the consequences, I explained all the ins and outs and the danger of it, and they intentionally chose that. So on the good side, it could possibly protect some people. On the bad side, it might mean that everybody needs new powers of attorney. If they pass this new law, we might have to get everybody new legal documents. So anything that was before that might not be able to. We'll see whether they grandfather them in, but I'm guessing they won't grandfather them in. So it's been proposed for the last couple of sessions. And it's proposed again. It's part of the package of bills from the Elder Abuse Task Force, and it's proposed. It's on the table, but it's not come up for hearing or anything yet. My friend that's on the Elder Abuse Task Force believes that it's very likely that it will get passed, but I don't have a time frame. But probably during this, before the governor's election, is because that would be a whole, the task force will change at that point. So probably within the next year and a half. Same thing with cameras in the nursing home. So Senator Runstead from Oakland County somewhere, had been proposing this for quite a while, making sure that there could be permission to have recording devices or cameras so that you can observe your mother or father or spouse or whatever. This is a tough one on both sides. On some ways, we kind of want to keep track. On some ways, there's some privacy issues, right? And especially what if you have a roommate, things like that. So this has gone back and forth. It's now been brought up again and proposed again. It got thrown out last time. Basically, the long-term care industry got involved and said, hey, we have some concerns about this. They made some amendments that there has to be waivers from everybody that would be on camera. There has to be notice posted on the door. There has to be all these protections. And one of the things I don't like is that it says that if you don't follow all of those rules and you have a recording device or camera, that none of that would be admissible in court. So if somebody is being abused or there's a caregiver that's not hurting somebody and they got it on camera, they wouldn't be able to use that in court. Well, that's what the proposed law says, And so it just encourages people to actually follow those rules. Make sure there's a posting, make sure you get waivers, and you get clarity. So we'll see where that one goes, but again, that one was kicked out last time, but it's been reproposed. We probably all know about this asset verification program. This has been around for a little bit. In my mind, that the Department of Health and Human Services has this like supercomputer that they put your name and picture in, and it pops out every financial transaction you've ever done. I'm sure it's not really like that, but the thing about it is, what you do is you go through the whole Medicaid process, and then at the end, when they're ready to approve you, that's when they put it through asset verification, which is a little irritating. You'd think they would do it at the beginning, but they do it at the end. It just kind of causes delays and things like that. But this is brand new, so this already took effect. That banks and credit unions now can put a hold on any transaction or even a hold on the account if they have any reasonable suspicion of exploitation of a vulnerable adult. And so then they would contact APS or law enforcement. On the one hand, of course, we want to prevent elder abuse transactions. We want the banks to step up and do that. On the other hand, I worry that sometimes it's a matter of we're doing a legitimate process, and the bank will slow down that process, particularly when it comes to Medicaid. So with Medicaid, sometimes we have to move money, and we have to move money relatively quickly. And if we're trying to move money and the bank then puts a hold on it for 10 days, and then another 10 days, and 30 days, it could mean that it's going to delay the Medicaid process. So it's a good idea. We just heard that the Senate has passed a law that the financial advisors would be able to do the same thing. This concerns me a little bit more than the banks, frankly. So we don't know. So first of all, this one says vulnerable adult. The financial advisor one says anybody over age 65. Okay. 65 isn't that old, first of all. Secondly, financial advisors have an incentive to put a hold on it, to then try to convince you not to move your money to another financial advisor or whatever. And so all they need is a reasonable suspicion. Pardon me? It does not make them mandated reporters. Yeah, that's a great point. It does not make them mandated reporters, and everybody in the state is a voluntary reporter, but there are certain people, social workers and others, that are mandatory reporters of suspected abuse. And so, yeah, I'm nervous about this. Apparently there's a federal regulation in what's called FINRA, which is the federal regulatory for certain financial advisors, that has allowed this for about a year, but they're trying to put it into Michigan law. We'll see where it goes. We had another law that, did it recently get passed? I think there was another law that recently got passed to make it easier, from the prosecutor's standpoint, easier to prosecute elder abuse. Because what their issue was, the previous law said vulnerable adult. And then they had to spend all this time proving that somebody was vulnerable. In fact, the Assistant Attorney General we were talking to the other day was saying they had to spend days proving that this 94-year-old was a vulnerable adult. And they had to get medical testimony and all this stuff. And they wanted a bright line rule that says if you're over this age and you've been somebody took your money or whatever, we can prosecute them under the elder abuse statutes. Well, originally they wanted it to be 65. Again, we said, boy, that seems like not right. 65, there's a whole lot of 65-year-olds that are not vulnerable adults. So we negotiated on that one to put it at 80. So I'm pretty sure that law did pass, right? Yeah, that law did pass. And so that's at 80 that they can prosecute for elder abuse, and they don't have to prove vulnerable adult. And so now there's a discrepancy between that law and the financial advisor law, so hopefully that all gets fixed. A couple different things. This other law, this is actually, I think, a good one too. There's a law that was passed in Michigan recently that allows a probate court to issue a limited guardian to facilitate visitation. So this came about for a lot of reasons, but one of them was Casey Kasem. prior to his death, his spouse was refusing to allow his children to visit him. And so his daughter has been going around the country kind of lobbying to get a law in place that makes it so that if the guardian is preventing visitation from the family or appropriate people, that the court has a way to deal with that. And so they passed the law in Michigan that would allow, if somebody's being denied access to their mom, their dad, their whatever, that they can go to the court and get a limited guardian. So it doesn't mean they're going to get access. It means that they're going to appoint somebody to look into it to see whether it's appropriate to limit their access. Sometimes it's appropriate to limit their access if they're causing trouble or trying to, steal from them or something. So this is an interesting case, and it's probably correctly decided. So remember earlier we talked about how independent living is different than assisted living and memory care and all of that. It also is different from a standpoint of liabilities. So this is a terrible case. So this person was kind of wandered away from their independent living, and then in winter, and they tried to get back in, and the door was locked, and they couldn't get back in, and they died. And then the family sued the place because they said, "Boy, that seems wrong," and it is wrong, right? But from a liability standpoint, they weren't liable, because independent living isn't committing to the care portion of things. They're committing to the room and board. And so they're not committing. Now, if it had been assisted living or memory care, they could have probably been liable. They could have probably, won that lawsuit. But because of an independent living. Now, this is an unpublished decision, meaning that it doesn't necessarily carry legal weight, but it's probably the accurate decision that independent living isn't actually liable because they don't provide care. They provide a protective environment. They provide room and board. We talked about ladybird deeds earlier, and so I put a picture of Lady Bird Johnson. Ladybird deeds actually were not named after Lady Bird Johnson, just to be clear on that. But everybody thinks they are, because why, if it's called a ladybird deed, why wouldn't it be named after? So what happened was there's a law school professor in Florida, and he would always give these examples. In my experience, law school professors are very quirky and very funny and very quirky. And so this one in particular would always put famous names in his examples. And so whenever he would be talking about this type of deed, sort of a beneficiary or a transfer after death deed, he would always use Lady Bird Johnson as in the example. Well, then one of his students wrote an article about it, law review article about it, and then he used that name. And after that, everybody now says, well, it's because Lady Bird and President Johnson used this in their estate plan. No, they didn't. There's no record of them ever using this technique in their estate plan, but that's what it is. Kelly went through some reasons why Lady Bird deeds may be not a good idea. Here's a really good reason why it's not necessarily a good idea. So, David, we're going to call him Uncle Dave, had a house. He also had an ex-wife. He wanted to leave his house to his niece, Dawn. And so he signed a ladybird deed, appropriately prepared ladybird deed that said, I, David, I want to keep this house. I want to be able to make whatever decisions. I can change my mind in the future if I want. But if I die and I haven't changed my mind, and that's not the wording of the deed, just to be clear, but if I die and I haven't changed my mind, then this house will go to Dawn. Uncle David died. Ex-wife, 6 days after he died, burned down his house. So niece Dawn, said, okay, well, that's pretty weird, but at least we have homeowners insurance. So she applied for the homeowners insurance. And State Farm, homeowners insurance said, you weren't insured. Because Uncle David was insured, but it transferred. The second of his death, it transferred to you, and the house burned down after that. 6 days after that, but the house burned down after that, so we don't have to pay. And the Court of Appeals in Minnesota said, yep, that's right, you don't have to pay. And they were right. And what's worse about Lady Bird deeds is there's not really a way to add, there wouldn't have been a way to add Dawn as an insured party because she didn't have any interest. You can't add somebody as an insured party, an insured party, if they don't have a current interest or even a future interest, some kind of established interest. With the Lady Bird deed, Dawn didn't have an interest because it's a contingency because Uncle Dave could have changed his mind. So the court was right. And we got a problem if you have a Lady Bird deed and the house burns down before you get a chance to put yourself on the insurance company probably doesn't have to pay. Now, that was Minnesota, but it's probably an accurate decision. Free Britney. All right, so one of the big things is, well, once you get under guardianship, so there's been this thing about once you get under guardianship, you're always under guardianship. We all know that shouldn't be the right way. But it really does feel that way sometimes. When somebody gets guardianship, it's like nearly impossible to get rid of it, as we saw with Brittany. Well, there was a case in Michigan. Gordon versus Guardian and Associates. And Mr. Gordon, I think, if it was Mr. So Gordon said, I don't need a guardian anymore. I needed one for a while, I don't need one anymore. Applied to have it removed. And the Court of Appeals said that in that hearing, they have to establish all the same rules that would have been required to get the guardian in the first place. In other words, it's not a lesser standard. They still have to prove the requirements. They have to prove the need. They have to prove the danger of not approving the guardianship. So in other words, it should be clearer that you should be able to get out of a guardianship. So that was a worthwhile court decision. We talked about unnecessary guardianships. We're just going to conclude, and then once we conclude, remember we got a couple of cleanup things we got to do here. Double check my time here. We have a particular opportunity this year to advocate for some change. So the elder law section of it's called the Elder Law and Disability Rights section of the State Bar of Michigan, has for many years been very active in lobbying and legislation and trying to make sure that we have laws and regulations that are good for our seniors. And so this year I'm chair of that section, and I have an ability to influence now what we're pushing. So I'm going to tell you a little bit about a few things that some of my priorities and what we're going to. I'll tell you, we're not going to accomplish these things this year. I'm going to at least start the ball rolling to try to accomplish some of these things, but most of these things take more than a year to accomplish. Additionally, Kelly, who you heard from earlier, is the vice president of the Michigan chapter of National Academy of Elder Law Attorneys. So again, she's going to have some influence too, particularly next year when she'll become president of that, the National Academy of Elder Law Attorneys, Michigan chapter. So a couple of my priorities is dealing with this income limit. We kind of accepted in Michigan that you can't get waiver or PACE if your income is a penny over $2,382 per month. That seems pretty arbitrary to me. And guess what? Most states have figured a way to work around it. Because not only would we allow our citizens to access home care, which they would prefer, or PACE services, which they would prefer, and not be institutionalized. And I don't mean to call skilled care an institutionalized, but I mean, in some ways it is. You're saying you have to go to a nursing home. So not only would it allow, just because they make a penny more than that, and several states have figured that out, but it's actually good public policy because several states have figured out that they spend less tax dollars on Medicaid when they allow more people to be on PACE and more people to be on waiver, because it costs less than having them be in skilled care. So it's good public policy, it's arbitrary and unfair, and we spent a whole lot of years in Michigan fighting for workers' rights so that we have an 8-hour workday and we get pensions, or we have, we protect our seniors. That's a big Michigan history, and now because we did that, we have people that have GM pensions and Ford pensions, and because of that, now they have to go to a nursing home if they ran out of money and need Medicaid. They can't get home care. They can't get PACE because they got that pension for $800 that we fought for in Michigan history. That doesn't make sense. And so other states have found a workaround. It's complicated. it's federal and state, and we got to get everybody lined up. It's not as easy as passing a law. I'd love to be able to pass a law saying we no longer have this income limit. That's not a possibility. We actually have to go through all these different agencies and things like that. But that's one of my goals, at least to start that conversation about how do we change that. Our section has done quite a bit with disability rights advocacy. One of the things is a member of our section was a lawyer at the courthouse in Detroit, and there wasn't an accessible bathroom. She worked on the 10th floor. Wasn't an accessible bathroom unless you went down to the basement, and most of the time that basement bathroom was locked, and she was expected to work there. And so we started sending letters, and we sent a letter to the county. They said it's a city problem. We sent a letter to the city. They said it was a county problem. And so we're probably going to file a lawsuit on this because they still haven't fixed it. And then you win some, you lose some. My Cousin Vinny is a good movie if you haven't watched it. But I started off this slide, when I first wrote it, it said, success in the courts. And we've had some success in the courts, but we've also had where we weren't successful in the courts. So I preferred the you win some, you lose some. And so we've had success with helping protect married couples with something called Sole Benefit Trusts. It went all the way up to the Michigan Supreme Court. Our group won in unanimous decision to allow us to protect assets for a married couple where only one spouse needs Medicaid. We've also had cases, including one of our own Mannor law cases, that went to the Court of Appeals that established the law on protective orders and support orders. So when they say, this amount of the, we got husband and wife, and let's say wife's income is lower, husband goes into the nursing home, only a portion of his income goes over to wife. If we can prove to the court that she can't afford, that she can't pay her bills with that, the court is allowed to issue a support order to lower that patient pay amount. Well, the state challenged us on that, challenged a few other attorneys. We took it to the Court of Appeals, and we were successful on that. And then we've had a matter where we were able to protect retirement assets where there's an IRA. IRAs can be very challenging because there's tax consequences of IRAs. And so we were, I think, the first one in the state to actually successfully get a retirement account protected without having to pay the taxes on it. In this particular, there's a couple ways to do it. There's another lawyer that has done it in one of the other strategies. We used a particular strategy. We were able to successfully get that through. But then there's been some protective order cases recently that have made it a little bit more difficult too. So we're going to have Savannah come back up, and she's going to give you some instructions. I just want to give you one last chance to say thank you for coming, thank you for being here. I'm hoping that the resources that we gave you, those 2 laminates, can be helpful for you throughout the year. We'll get you another one next year. Even if you don't come to boot camp next year, just call us and we'll get you another one with the updated numbers on it and things like that. Anytime you have anything that we can help you with, feel free to reach out to us. I appreciate you coming.